Very much for joining us today. I'm Matt Valliere. I'm the Executive Director for the Institute for Patients' Rights, an organizational plaintiff in the lawsuit we're here to discuss. I'll be your host today. For the benefit of some people with disabilities, I'm an early 40s man of color, dark wavy hair, clean shaven, olive complexion, wearing a pink checked button down shirt and a sky blue blazer in front of a blurred gray background. Our broken medical system is driven by a profits before people structure. People are not getting the care they deserve, and choices are often artificially limited by financially motivated players. Too often, medical professionals and society on the whole view life with a disability as less worth living, less worthy of care, scarce medical resources and healthcare dollars, better off dead. We have 5 experts here for you today who will provide our position, purpose, and arguments in the case we have filed in the U.S. District Court in the Central District of California to permanently enjoin the state's assisted suicide law, the so-called End-of-Life Options Act. We argue that the statute violates federal anti-discrimination law that protects the rights of people with disabilities and the U.S. Constitution. Today we'll have Michael Bean, who's the co-founding partner at Rosen, Bean, Galvin, and Grunfeld, one of the top firms in the nation for constitutional rights, healthcare, disability rights, mental health care for prisoners. Mr. Bean concentrates his practice on complex litigation, class actions, constitutional and civil rights law, disability rights, and attorney's fees disputes. We also have Diane Coleman. She's the president and CEO of Not Dead Yet, an organizational plaintiff in the case, and a national disability rights group, which she founded in 1996 to give voice to disability rights opposition to the legalization of assisted suicide and euthanasia. Her colleague, her colleague Anita Cameron, who's the director of Minority Outreach, also from Not Dead Yet, has been a disability rights activist for nearly 40 years, and she's also an ADAPT organizer. Ingrid Tischer, who is one of the individual plaintiffs in the case, is an organizational consultant and coach specializing in work disability balance for disabled, aging, and chronically ill workers and family caregivers. She has worked in the Bay Area as a nonprofit manager and fundraiser for 30 years. Her blog, Tales from the Crypt, explores the emotional landscape of disability and systemic ableism. And finally, we have Vincenzo Piscopo, the president and CEO of United Spinal Association, an organizational plaintiff in the case. United Spinal is the largest membership organization of people with spinal cord injuries and disorders in the United States. Vincenzo is a chair user himself, and prior to United Spinal, worked on disability inclusion in the corporate world and for access to durable medical equipment in developing nations. We'll also have on ASL interpreters for those who benefit from that. A little bit of housekeeping. We're going to take all questions via the Q&A function. So if you move your cursor around, you can see the menu at the bottom, and there's little text bubbles with a Q&A below. You can click that to pull up the option to ask questions by typing them in. Please, when you do ask a question, which you can do at any time during the presentation, type the question, your name, your media outlet, and if the question is for a specific panelist, please indicate that. If afterwards you have any further media requests, please contact Bill Pierce at APCO Worldwide. His email address is wpierce, P-I-R-C-E, at apcoworldwide.com. The session will be recorded, and we'll share the link on our platforms afterwards and with anyone who received the full press release. Panel and hosts, for anyone who's not speaking, please do keep your mic on mute. And if you can benefit from closed captions, here's how to turn them on. Again, if you move your cursor around, you'll see at the very far right next to the red leave button, there are 3 dots. You can click on that with more, the word more underneath. It shows the option for captions. If you just click that option, you can have show captions, and then there are various options to make the captions larger and smaller to suit your needs. So for additional information, you can also find up-to-date information on the case at endassistedsuicide.org. So thank you for coming. And Michael, would you please start us off today? Take it away.
Hi, my name is Michael Bean. Thank you, Matt, for the introduction. I am a 67-year-old white male with a gray hair and a gray beard. I'm wearing a reddish brown tie and a blue shirt and a black jacket. My pronouns are he and him. Physician-assisted suicide is a form of euthanasia. It is not only a revival of old eugenic ideologies, but violates federal disability rights laws and federal constitutional provisions, which protect persons with disabilities from discrimination, exclusion, and life-threatening government laws and policies. Under federal law, a public entity like the state of California may not withhold services or make services available on unequal terms on the basis of disability. The state and local government defendant agencies and officials named in this action fund and operate systems of public health, social services, medical profession regulation, and law enforcement to provide protective services for people who express suicidality and to prevent medical professionals, caregivers, family members from taking advantage of or encouraging a person's impulse for self-harm or suicide. Through the state's physician-assisted suicide law, however, this entire protective network of services is withheld from the plaintiffs and their members solely on the basis of a doctor's good faith diagnosis of what they call a terminal disability. EOLA, End of Life Options Act, is a discriminatory scheme which creates a two-tiered medical system in which people who express suicidal thoughts receive radically different treatment responses by their physicians and protections from the state, depending on whether the person has what the physician deems to be a terminal disease, which by definition is a disability under the American Disabilities Act. Plaintiffs are all organizations with members who have disabilities, individual persons with disabilities, and/or organizations that advocate for persons with disabilities. This act, this physician-assisted suicide law here in California, is situated within a long history of American state laws and practices directly harming and discriminating against people with disabilities on the grounds that these people's lives are not as worthy of protection as others. The COVID-19 pandemic recently revealed how certain groups of people are considered disposable by the state, such as older, disabled, and chronically ill people, as well as how people are even more disproportionately impacted by state-based medical discrimination policies if they're economically marginalized or a person of color. Black people, for example, are particularly at risk from this law because racist healthcare policies lead to limited choices and poorer outcomes, and make it likely that doctors will write off patients as terminal and not worthy of life-preserving care. As California's official healthcare policy, EOLOA, that's EOLOA, the name of the act, steers vulnerable people to their deaths instead of providing care and supportive services. Defendant California agencies and officials are cynically generous in providing this freedom to choose death by suicide, but drastically restrict the provision of appropriate palliative, hospice, in-home care, and other supportive and protective services, such that the actual supply and availability of alternatives to physician-assisted suicide is woefully inadequate to meet the demands of the state's aging, disabled, and chronically ill population. Instead of ensuring viable, appropriate mental health and medical care options that promote patient well-being and true autonomy, this act presents a false choice of living without necessary health care or dying by suicide with the, quote, help of a physician. This law discriminates against people with terminal disabilities by depriving them of protections afforded other persons under California law in violations of the ADA and Section 504 of the Rehabilitation Act of 1973. Everything that a state does, all programs and activities, are covered by Title II of the ADA. Any state agency that receives federal funds to do its work is covered by the Rehabilitation Act of 1973. The state of California has suicide prevention programs that are designed to ensure that a person's expression of suicidal ideation triggers mental health care. But this act deprives plaintiffs and their members access to these life-preserving interventions because of their disabilities. Medical professionals under this law are immunized and cannot be held civilly liable, nor criminally prosecuted for assisting the suicide of a person with terminal disabilities, so long as they comply with the Act's very minimal requirements. The same doctor is subject to criminal and civil liability if he provides a far less dangerous dose of opioids to a non-terminal patient in pain who later overdoses and dies. This act shields physician-assisted suicide deaths from law enforcement investigation and prosecution solely because the person who died by suicide had what the doctor believed was a terminal disability. EOLA does not reasonably advance its claimed purposes of enabling autonomous choices in dying and relieving suffering, and violates the Equal Protection Clause of the 14th Amendment by treating differently people with terminal disabilities as compared to everyone else who expresses a wish to die to their medical doctor. There's no rational basis for the Act's terminal classification, given that physicians often misdiagnose patients as having terminal diseases. Physicians' prognosis of 6 months to live is often fallible, and the terminal classification includes people who can live a longer lifespan with treatment and supports, for example, a diabetic taking insulin, but not without them. This Act's very purpose and core requirement, providing an early death to someone who will die from a terminal illness within 6 months, is irrational, unreliable, and discriminatory in violation of both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. This Act also violates the Due Process Clause of the 14th Amendment by failing to include sufficient safeguards to ensure that a judgment-impaired or unduly influenced person does not receive or ingest physician-assisted suicide drugs without adequate due process. The Act's failure to require an exhaustion or at least evidence of these other alternatives to assisted suicide, including suicide prevention services, palliative care, hospice care, other personal support services currently provided by the state, violates due process. The Act creates an unregulated zone, which allows a free-for-all with no independent or public oversight into whether people who die by physician-assisted suicide are actually close to death, have a treatable mental disorder, are coerced into death by another person, or lack feasible alternatives. The amendment to California's law that passed very recently and went into effect a little more than a year ago made the Act even more dangerous for the plaintiffs and for the community. The amendment is what I call a fast track to suicide. 48 hours instead of 15 days. No personal attestation. These are removal of two of the important safeguards that were advertised when this Act was passed. The amended Act even now requires physician participation, even by physicians who have a moral, ethical, professional, or other objection to participating. We brought this lawsuit now because our plaintiffs, are gravely at risk by this law. And we will seek to enjoin the law as a violation of federal disability law and the federal Constitution. Thank you.
Thanks very much for that legal explanation, Mike. Very helpful. For the media, just Mike again is from Rosenbein, Galvin, and Grunfeld. They are the law firm on the case with lawyer Haben Girma as co-counsel. For any additional information from Rosenbein, Galvin, and Grunfeld, or from Mike personally, you can contact their PR contact. His name is Carl Whitaker. His contact information is in the press release, but his email address is Carl, C-A-R-L, at whitakercom.com. So WHITAKERCOM.com. Next up, we have Diane Coleman. Diane, please share your thoughts.
Thanks, Matt. Hello, I'm a white woman in a motorized wheelchair wearing a red dress and sweater and a breathing mask, turning 70 in a few months. So much for the doctors who told my parents I'd die by the age of 12. This lawsuit is a long-held dream come true for Not Dead Yet. Our 27-year anniversary is this week. As we stated in our first Friend of the Court brief, filed in 1996 in the U.S. Supreme Court, discrimination against people with severe disabilities pervades our society. Assisted suicide is the most lethal form of such discrimination. Applied only to people with significant health impairments, assisted suicide is the ultimate expression of society's fear and revulsion regarding disability. Those words are as true today as they were then. Assisted suicide is just one of the many symptoms of an ableist, eugenic society that believes life with a disability is a fate worse than death, that people with significant disabilities are better off dead. My own medical history and increasing need for breathing technology to survive would lead most medical providers to consider me terminal. If I became despondent over the daily frustrations of disability discrimination, or a new medical setback, or typical human problems with work, marriage, or finances, I'm sure I could find 2 qualified providers to agree that I'm eligible for assisted suicide. I couldn't count on the same suicide prevention that a non-disabled person would receive. While typical people who say they want to die get suicide prevention, under assisted suicide laws, we get suicide assistance. This double standard based on disability violates our civil rights laws. Everyone who dies by assisted suicide is disabled. Some old, some young, some actually terminal, some not. Assisted suicide data continue to show that unmet disability-related needs are at the heart of requests for assisted suicide, with inadequate supports leading to feelings of losing autonomy and being a burden on others. The creeping acceptance and expansion of assisted suicide laws promise increased profits for insurers while threatening even greater healthcare disparities that endanger the lives and well-being of disabled people, especially Black people, people of color, LGBTQIA+ folks, and other multiply marginalized communities who already face well-documented barriers to effective healthcare. This lawsuit is our fight against a society, a healthcare system, and insurance industry that tells too many of us to give up on living, to hurry up and die. For all of us who've been denied the help we need to live, no, we're not going to lay down and die. We're not dead yet, and we're fighting back.
That's fantastic. Thanks, Diane. Appreciate your advocacy. Anita, also from Not Dead Yet, are you with us? Yep, great. Anita, would you please offer some comments on the lawsuit and on your thoughts about the assisted suicide public policy?
Sure. Hi, my name is Anita Cameron. I am a 57-year-old Black woman with long locks and caramel colored skin. My pronouns are she, her, hers. I'm wearing a wine colored sweater. I'm going to read my remarks, and so I'm going to turn off my camera while I'm reading my remarks, and then I'll come back on. So as I said, my name is Anita Cameron. I'm a 57-year-old Black woman with multiple disabilities. I am a disability justice activist. And for 37 years, I've organized with ADAPT, a national grassroots disability organization known for direct action and nonviolent civil disobedience. I participated in historic actions like the 1990 Capitol Crawl and Rotunda Takeover, pushing successfully for the passage of the Americans with Disabilities Act, as well as the 2017 Fight to Save Medicaid, where disabled people were dragged out of congressional offices. I have been arrested 140 times fighting for civil and human rights for the disability community. And my experiences shaped my views against assisted suicide. So in 2009, while living in Washington State, my mother was determined to have end-stage chronic obstructive pulmonary disease and placed in hospice. Her doctor had us so convinced that she was dying that after 6 months in hospice, she moved home to Colorado to die. But 6 weeks later, she and I were arrested together in Washington, D.C., fighting for disability rights. After that, she became active in her community and lived almost 12 years more. Assisted suicide is dangerous, especially for disabled, sick folks, seniors, and marginalized people. It creates a two-tiered system where one's state of health determines whether one receives adequate care. As a Black disabled woman, I have experienced both racial and disability discrimination in healthcare. The most blatant example of this was when I went to the emergency department last year in intractable pain. A white woman, also in pain, was next to me. She got Dilaudid, a potent pain medication, while I got a pat on the shoulder and sent home. Research shows that Black patients are also, they're less likely to receive adequate pain treatment due to false beliefs about biological differences between Blacks and whites, which will add to further pressure to seek assisted suicide. So how does racial disparities in healthcare relate to assisted suicide? So research has documented Black, Asian, and Hispanic persons regularly receive barriers to palliative and hospice care utilization. A 2016 JAMA internal medicine study found that hospice patients were less likely to be visited by staff in their last 2 days of life if they were Black. Even more alarming, California nursing facilities with higher numbers of Black and Latino residents have had higher rates of death. And although Black people and other people of color request assisted suicide less than white people at this point, as the practice is normalized, they're more at risk of pressure to do so. First, because racial disparities in healthcare leads to limited health choices and poor health outcomes, and that includes death. Economic disparities make it less likely that patients can afford life-saving treatment and more likely that doctors will write off patients as terminal, thus eligible for assisted suicide. So as long as racial disparities and disability discrimination in our healthcare system exists, there's no place for assisted suicide. And stopping California's assisted suicide law is both a disability rights and a health equity issue.
Thank you for those powerful words, Anita. Greatly appreciate you. Next up, we have Ingrid Tischer, again, one of the individual plaintiffs in the case. Ingrid, please. Ingrid, you're on mute.
Thank you, Matt. Hello, I'm Ingrid Tischer. I am a middle-aged white woman with hair that is grayish blonde and pulled back. I'm wearing a dark green dress against a blurred out background, and I'm a very pale-skinned person. And as you may be able to tell, I speak with some labored breathing. I'm here today because California's End-of-Life Option Act, as others have said, creates a two-tiered system of healthcare that's based on disability, in which a non-disabled person is steered towards suicide prevention, and the disabled person is steered toward a suicide prescription. This is discriminatory. It also denies the reality that assisted suicide laws have normalized suicide, and they've increased suicide contagion. The law gets in your head. That's what happened to me. For me, diagnoses and doctors' other limitations are presumptive parts of decision-making in medicine, including at end of life. And I have firsthand knowledge of how medical certainty on one day so often becomes outdated information the next. I'm still here at 57, and to my knowledge, I did not die before turning 40. I was misdiagnosed with cerebral palsy until I was 10, and then re-diagnosed with muscular dystrophy. And I now know that I have a polyneuropathy that has caused quadriplegia and led to sleep apnea and chronic respiratory insufficiency. I also live with depression and anxiety. I have neurodegeneration and muscle weakness, and this means that I have a limited ability to breathe and very limited use of my arms and hands and to walk about. I quickly become, quote, terminal if there is any interruption in getting my services and supports. In January of 2021, after a fall at home and months of increasing swelling in my feet and legs, I was taken by ambulance to Kaiser Permanente Oakland Medical Center. I was admitted to the acute care unit for neurological patients, where I was diagnosed with edema and pneumonia, put on antibiotics, and placed on a breathing machine. I was offered a consultation with a psychiatrist, and it resulted in a diagnosis of depression and anxiety, and a treatment plan that included psychiatric medication, psychosocial therapy, and meeting with a social worker. My mental health status was well documented. Concerned about my rapid muscular degeneration, I asked the neurologist about participating in Kaiser's inpatient rehabilitation program versus being sent to a non-Kaiser rehab facility. I was petrified of these skilled nursing facilities because of my extreme vulnerability to COVID and the horrifying rates of death from COVID in such facilities at the time. The neurologist responded that Kaiser doesn't take patients with progressive disabling conditions like mine because the admitting criteria requires a likelihood that I regain my original baseline of function. When I asked if that wasn't exclusionary of anybody like me who has a progressive condition, he replied that it wasn't discriminatory. It was just the program's admissions policy, and no one can do anything about that. I asked why the criteria couldn't simply be that a patient has the capacity to work toward the best health possible, like I did. The neurologist gestured toward my body in the hospital bed, the body that was wearing an oxygen mask and in acute emotional distress, and said, "Well, look at you. You've always known this was coming, been coming for a long time. And there's nothing we can really do about it. For me, this was an incredible gut punch. I have a degenerative condition. I grew up with it. I wasn't expecting to start tap dancing. But when he said there's nothing we can do about it, it was as if he had given up on my survival. This led to an extended panic attack. I was convinced that death had shown up. I made plans to say goodbye to my nieces and nephews and prepared to talk to my husband the next day about me going home to die. I accepted assisted suicide as an option. It was better than getting COVID in a skilled nursing facility. Luckily for me, my husband managed to convince me that I wasn't dying and that he understood how scared I was. He told me the doctor was wrong. What is so deeply unnerving to me is how I became ready in that moment for assisted suicide and how I got there in such a short period of time. Within 24 hours, I somehow evolved from being a committed disability rights activist who has long opposed assisted suicide to believing that it was really the best option for someone like me. I feel like I survived due to many wonderful health professionals. I survived because of my middle classness and my white privilege and my husband's wholehearted devotion that included cheerfully changing my diapers when I went home, which I did. I slowly healed because of access to in-home physical therapy, psychiatric meds, and psychotherapy to manage my chronic medical conditions. And that includes, sadly, just a whole lot of luck. What happened to me demonstrates how vulnerable even I was to a suboptimal doctor and the prospect of going to a skilled nursing facility. While I ultimately recovered, I do fear that I could once again find myself in the care of a doctor who refuses me supportive services and could instead steer me toward physician-assisted suicide as the solution to my medical needs. I'm afraid of what I have found in myself when it comes to desiring suicide. It's very odd when I hear doctors insist that I have nothing to worry about, that there are safeguards in the law. I want to ask them, why are you thinking magically instead of thinking critically? You're refusing to recognize that you have limitations. The California law doesn't require oversight or reporting or data collection. And you know that doctors do have a poor opinion of a disabled person's quality of life. Doctors look at disability like vice cops look at human nature. The bias is built in. And I need them to think critically about how assisted suicide legislation operates within a system that has an ongoing history of eugenics. Despite all that, I'm not here to criticize people who desire assisted suicide. I know firsthand the reasons why disabled people come to feel like suicide is a solution, not a problem. Assisted suicide felt desirable and so rational when I was hospitalized with non-COVID pneumonia and being faced with being sent to a substandard skilled nursing facility where everyone with my respiratory problems was dying. The idea that I'll be magically exempt from any doctor misunderstanding my complex health conditions or responding to my suicidal ideation with a prescription instead of prevention is just that. It's magical. When someone asks me what I think they should do, though, if I deny them that option, I tell them that their fears are justified, given the control that healthcare insurers wield and the lack of in-home care, especially quality hospice, and how all of that is amplified if you're Black or a person of color. I would want them to know their rights They have the right to have an advanced medical directive that gives power to their decisions. They have the right to refuse medical treatment at any time and to change their mind at any time. Finally, they have the right to palliative sedation, which can safely ease their final moments at home under the care of a medical provider. Unlike physician-assisted suicide that provides only a prescription and requires no medically licensed assistance. I want all of us to see assisted suicide legislation for what it is. The painful proof that many people fear death less than not being able to escape our broken healthcare system. This all calls for enforcing our disability rights and strengthening medical standards, not undermining them and calling it choice. Thank you.
Thank you so much, Ingrid. It's a powerful story. I'm sorry you had to go through all that.
Thank you.
Next, we have Vincenzo Piscopo, again, the CEO and president of United Spinal Association. Enzo.
Thank you, Matt. Hello, everybody. I am a 55-year-old Latino man with a short, dark hair, wearing glasses. I'm wearing a blue jacket with a light blue shirt, and I'm sitting in my wheelchair. Behind me is a bookshelf with a large picture of the skyline of Atlanta at night. 13 years ago, when I was 42 years old, at the prime of my life and professional career, I suffered a spinal cord injury. For those of you that don't know, spinal cord injuries don't only impact your ability to walk, but also your sexual, bowel, bladder functions, and sometimes your ability to breathe, which in many cases is considered terminally ill, among other complications. The first 3 months after my injury was critical, not only for my physical health, but also for my mental health. I did not know how I was going to live after being snatched of all my abilities. On top of that, I had complications after complications. And because all of this, my mental health was impacted. I was overwhelmed by suicidal thoughts and ideation. However, I was fortunate to have a very strong support system, a strong family, great support from my employer at the time, the Coca-Cola Company, which offered insurance that allowed me to receive outstanding care from the Shepherd Center in Atlanta that included hours of physical, occupational, recreational, and most importantly, mental health therapies. Close to $1 million in expenses that I guess my health insurance would have loved to avoid. Thanks to that, I was able to successfully recover and go back to my life, work, provide for and enjoy my 4 kids, and most importantly, give back to my community. My story is very similar to many people that suffer traumatic experiences as spinal cord injuries. Same as me, many in similar conditions that received the right care were able to beat the odds and survive to live amazing lives. The only difference that there might be in many of the cases is that they're not offered the array of therapies and choices available to live and dramatically improve their health and their quality of life and make them terminally ill. Then the option of suicide becomes all of a sudden attractive and extremely cheap and easy for the healthcare system. I am so happy that I recovered, and I'm so happy with the life that I live. Many members of our community with worse injuries that went through the same are also as happy as I am. We in United Spinal decided to join this lawsuit because we represent the 300 individuals in this country that have a spinal cord injury and the 18,000 that get spinal cord injuries every year. As we said in our press release, assisted suicide laws make it far too simple for the system to fall short in meeting the needs of people with disabilities and instead provide a cheap and easy way out. Our community, the community of people with spinal cord injury, is a vibrant community that when we are offered all the options available to be able to live and have a quality of life, we are able to enjoy our lives and in many cases continue to work, provide for our families, and pay taxes. Our folks need choices, true choices, and a healthcare system that will not give up on them, but will provide them with all the options that are available despite our disabilities that we have the right to. Thank you.
Thank you, Vincenzo. It's a very powerful story. Also, so grateful for you and for United Spinal. There's time now for questions. We have still 15 minutes. Just for everyone else's benefit, Peter Laffin from the Washington Examiner asked Diane Coleman. He said, I believe Ms. Coleman said that unmet disability needs represent the majority of requests for assisted suicide. Is there data you could share with me that confirms this? And Diane answered that the Oregon reports include data on the reasons people request assisted suicide. Diane, I think it might be helpful for everyone to hear what those top 5 reasons generally are and how you see those as all disability related concerns.
The top 5 reasons that show up in the Oregon reports, which is really the primary state that has that data, although I should note that California collects it in its forms, but does not report it on their site, which I'm not sure why that would be the case. But the reasons that have shown up for the last 25 years in Oregon are feelings of loss of autonomy, distress at not being able to engage in the same activities as before, that the individual may have found enjoyable, a feeling of loss of dignity, difficulty in controlling bodily functions such as incontinence, and feelings of being a burden on others, caregivers, and family. So the ones that really jump out to me with respect to policy issues is the difficulty of people getting in-home personal care services that are delivered on the what we call independent living model, where the individual or their family members have a strong say in how those services are delivered. So they're called consumer controlled attendant services or consumer controlled personal care. The struggle to get that is a long-standing battle where over the last 30 years with ADAPT, the group that Anita has been arrested with, and so have I, although I can't compete with 140 arrests. I've only got about 60. But you know, that issue is one where great progress has been made in many states, but it's still a state-by-state issue. And so the importance of getting that area of needs met is central to the feelings of autonomy, dignity, and the issue of feeling like a burden on unpaid caregivers.
And I'll just follow up with my experience of yesterday, spending the day with our other individual plaintiff, Lonnie Van Hook, where he explained to me that those attendant services are very difficult to get, even when the state approves them for you. So and for him, he often gets sent people who are very new and not very well trained. And so that as soon as he and his family are able to train them in his care, they end up getting moved on to another person with disabilities. Then he has to start over at step one. So it's a difficult thing to imagine, but to have every single doctor's appointment, every single aspect of your life, you need some help from somebody else, and yet there's not enough of the help. It's very difficult to get the help hired, and then once the help is hired, to have people who are they have the skills necessary for specific disabilities at hand or the needs at hand. It's just Lonnie talks about the attendant services, the dearth of that, drives some with disabilities, including his own, to real despondence and demoralization. Because it often means isolation, not being able to be mobile, not being able to go to work or enjoy your family, things like this. Just it really is difficult. So
One of the big fights related to that is fair pay for home care. Because that is one of the big factors in how to maintain an adequate caregiving workforce. And this has been talked about in the National Council on Aging committees I've been on over the years. And I could just say, it's like we knew this would be a reality as things move forward. And yet it's been difficult to get policymakers to adequately address it. So it gets to the point that it feels like, well, back to hurry up and die.
and I think that's when Lonnie explained to me that his devising an entire plan to kill himself by assisted suicide, the initial precipitation of that decision came from feelings of being a burden on his family, which is one of those top 5 reasons that people list for opting for assisted suicide in legal states. Peter Laffin, also again from the Washington Examiner, had a second question. This is kind of open to the group. So, can someone with depression be considered terminal under the law? And so I take his question to mean only with depression, not with other additional disabilities.
Try to take a shot at that.
Please.
So California's law has no requirement of a mental health evaluation before a physician provides physician-assisted suicide. There's nothing that says that someone with depression is ineligible. There's a reference to if someone has a major mental health disorder, they're supposed to be referred for a mental health evaluation. But our understanding is that rarely happens. California doesn't report how often that happens. Oregon does, and it happens in a very, very small number of cases, approximately 3 to 5%. So the law also says that the fact that someone is expressing a desire to kill themselves shouldn't be evidence of the fact that they have a mental illness. And if you think about that, that's kind of bizarre. Since normally expressing a desire to kill oneself is significant evidence of a problem that needs to be addressed. And it just shows how dystopian is a word that comes to mind. This law is it's setting up, and as I was thinking about this morning, kind of an Orwellian experience. The law also says that suicide is not suicide. It actually says if you could kill yourself under this law, you are not committing suicide. what does that mean? How can a law say that what you're doing is not what you are doing? Anyway, I think that the answer is someone with depression can be considered terminal under this law. And the studies show that people with depression do make use of this law and are not excluded from it. And that's one of the grave dangers.
Thank you, Mike. Ingrid, please follow up.
Yeah, I think this is such a fascinating example of how there's the policy on paper, and then there is it out in the real world. And in my experience, and I do have firsthand experience, it's that depression is not necessarily easily recognized. It can be quite subtle. And I know that I was only diagnosed with depression when I was 55 and in the middle of a severe depressive episode. And in retrospect, the psychiatrist told me that I had probably always had depression, but it had never been recognized as such, in part because when I expressed feelings of stress or despair or anything, my doctors tended to say, well, you know, that's normal given your disability. So it's as if when you have a neuromuscular condition that's degenerative, depression comes standard with the package. It's not an add-on. And that, to me, was a big part of why I never gave myself the support of saying I live with depression and could get help for it. I thought it was just a condition that was in my landscape and inescapable. It's like the depression that dare not speak its name or something. And as I really have to say, the thing that Mike was talking about around terminology and the Orwellian misuse of language when it comes to assisted suicide, you know, it's a type of euthanasia, and it gets euphemized, or it gets, and I feel like that's what people are trying to do to me sometimes. They're trying to euphemize me. I'm not killing myself. I'm being dignified. And I think playing with the language is really insidious. And I don't think that having a neurodegenerative disease makes my desire desire for suicide somehow this rational act that has nothing of emotion behind it and no fear. So I'm glad you brought that up.
Thanks, Ingrid. Enzo, please follow up.
Yeah, Matt, I just want to share an example, somewhat related to what we're talking about right now, that I think can illustrate a little bit of of our reasoning. So if you are going through a depression and you have suicidal thoughts, and I'm talking about an able-bodied person without a disability, goes to their general physician, the general physician will send that person to a psychiatric doctor or to a therapist. If I am a quadriplegic, I just suffer quadriplegia and I am on respirator, I need a respirator to live, and I want to kill myself, then I'm not taking. In California, very likely I'm going to be said, you know what, there is the option of assisted suicide there, right? Because, so the difference between the two is the disability that makes it very blatantly discriminatory. For a person with quadriplegia that needs additional care, and if he doesn't get that care, could die, which in turn means terminally ill, what that person needs at that time is all the health mental care, and a whole other things that need to be addressed. That after they're addressed, you address, their suicidal thoughts might be addressed, and therefore, avoid taking their life. It's like I suffer an injury, I get a whole bunch of complications that make me terminally ill. The solution there is to give you a pill to die. Where the solution should be, let's address all those things that are happening in your life that are making you want to take your life. And let's give you the support that you need. That takes a little bit more time. It's a little bit more difficult. It's a little bit more expensive, but it saves your life. So I just want to share that because I think it allows you to see where this law is very discriminatory.
Thank you, Enzo. Yeah, so it's the exact scenario that you described is what Lonnie Van Hook described about his plan to kill himself with assisted suicide. Is that he expressed that desire to harm and kill himself in the medical setting, and the medical professionals did not even once offer him mental health care, suicide prevention care. So with that, we have 1 minute left. I would just like to thank everybody for joining us today. Thank you to all the panelists and for the courage that this law firm and this group of plaintiffs has shown in really standing up for the rights of people with disabilities and for equity in healthcare. I'm grateful for all of the journalists who have taken the time to come today and listen to this recording afterwards. Again, if you have any questions or follow-up, please do contact Bill Pierce at APCO Worldwide. So it's WEIERCE at APCOworldwide.com. Again, thanks very much for your interest in our lawsuit. I hope you have a wonderful day.